Mm. Good morning, everyone, and welcome to the Sridhar Rampal Center's Virtual Trade and Investment Forum. My name is Adila Lewis. I'm a researcher at the SRC, and today I'm serving as moderator. The purpose of today's Virtual Trade and Investment Forum is to discuss the findings of the policy brief entitled Caribbean and African SIDS International Investment Agreements and Climate Action, which analyzes the international investment agreements of Caribbean and African SIDS and probes whether they help or hinder the climate action of these countries. Today, we are fortunate to be joined by the author, Ms. Alicia Nichols. Ms. Nichols is an international trade specialist and trade researcher at the SRC. She is a lecturer in the SRC's Masters in International Trade Policy program and a part-time lecturer in the Political Economy of International Trade and Finance. She holds a Bachelor of Science in Political Science, a Bachelor of Laws, and a Master's in International Trade Policy from the University of the West Indies. She also holds the FIT Diploma in International Trade from the Forum of International Trade Teaching and the Postgraduate Diploma in University Teaching and Learning from the University of the West Indies. Also joining us today as our expert discussant is Dr. Jason Haynes, Associate Professor of Law and Deputy Head of Postgraduate Studies at the University of Birmingham. Dr. Haynes joined Birmingham Law School in 2022, having previously served as Senior Lecturer in Law and Deputy Dean for Graduate Studies and Research at the University of the West Indies Cape Hill campus in Barbados. Before joining the university's Cape Hill campus, he was a lecturer in law at the Mona campus in Jamaica. He also taught at Durham Law School. He qualified as a solicitor and served as Senior Legal Officer jointly for the United States Embassy and British High Commission in Barbados and was Secretary General of the Arbitration and Mediation Court of the Caribbean. He is a Fellow of the Higher Education Academy and an Academic Fellow of the Honorable Society of Middle Temple. He was an O'Brien Fellow in Residence at McGill University. At Birmingham Law School, Dr. Haynes also serves as Deputy Head of Research and Deputy Head of Postgraduate Studies and teaches on the modules Contemporary Issues in International Trade Law and Global Law and Globalization. I want to begin by thanking both our discussant and our author, Alicia Nichols, for joining us today. And I'm sure that I look forward to each of their interventions and what promises to be an incredibly insightful discussion. I will now hand over to Ms. Nichols.
Thank you so much, Madam Moderator. Good morning to you and good morning to everyone. Thank you so much for coming. First, I want to extend a sincere thank you to my colleague who has kindly agreed to moderate, Ms. Adila Lewis, to Dr. Jason Haynes for being the expert discussant, to you, the audience, and of course to the reviewers who kindly gave of their time to review drafts of this paper that was sent to them. And this presentation is based on research that I had conducted for an SRC policy brief entitled Caribbean and African SIDS International Investment Agreements on Climate Action, released in June this year. International law policy is an area that has always fascinated me, and there's been a lot of scholarly discussion and policy discourse about the inadequacy of the current international investment law regime. And just to make sure we're all on the same page, the international investment law regime that principally comprises the network of international investment agreements, so bilateral investment treaties, treaties with investment provisions that countries have signed. And according to UNCTAD's IIA Navigator, total bits are about 2,828, of which 2,220 are in force, and there are 442 treaties with investment provisions, of which 366 are in force. So for some context, there are two reasons why I decided to look at this nexus between Caribbean SIDS IIAs and their climate action. First, as Sonaraja in his 2021 book noted, he explains that an assumption underpinning the investment regime is that it will lead to increased investments and ultimately increased prosperity and economic development for countries. And turning to the Sustainable Development Goals, scaling up FDI and SDG related sectors is seen as one of the ways in which countries could finance their achievement of these goals. And many of you would be aware that UNCTAD recently released its latest trade and development report, and it noted that despite there being an increase in, for example, renewable energy related investments in the years following the Paris Agreement's conclusion, developing countries still face a very significant investment gap in sustainable investments, about $4 trillion dollar investment gap. So that's significant. And there's the belief that foreign direct investment could help in terms of helping to address that gap. But this is not automatic, right? And it would depend on whether the agreements that we have, among other things, but including the agreements that we have, to what extent do they encourage sustainable investment? And secondly, as states amplify their climate ambitions and intensify their climate actions, there's a potential for more climate-related investment disputes arising from conflicts between investors' commercial interests and the state's regulatory interests. So given that context, the questions that guided my research were really, how fit for purpose are Caribbean and African SIDS, current IIAs, for promoting investment that serves their climate action goals? To what extent do current investment provisions in these agreements open up these countries' climate adaptation and mitigation measures to legal exposure to investor claims? And then in what ways could Caribbean and African SIDS IIAs be more conducive towards the twin goals of promoting investment for sustainable development and supporting their climate goals? And this paper, because this is a academic forum, this paper aims to contribute to the wider ongoing international investment law reform conversation in the academic literature, which recognizes that the investment law regime is heavily skewed towards the protection of foreign investors, even where a host state's development interests might be harmed. And there is therefore the need to ensure that treaty-based investor protections do not constrain co-states' ability to regulate in the public interest, particularly with regard to environmental, public, and human rights matters. And there's a growing body of scholarship on this, both in terms of the academic literature and the policy literature. So Brock, Bernasconi, UNCTAD, IISD, Sauvant, World Economic Forum, and of course, my learned discussant, Dr. Jason Haynes, would have done a lot of work looking at analyzing the current investment law framework and looking at ways in which the current framework is not necessarily fit for purpose. And also they've looked at the interplay between climate action and investment and sustainable development. And in the region, you also have studies by Behari and Koritzi, which analyze how international investment arbitral tribunals have handled environmental disputes. This work does a comparative approach, and turning to the methodology that I use, I relied on desk research using publicly available information. So I gathered the legal text of existent IIAs, so BITs and treaties with investment provisions in force for 6 African SIDS: Cabo Verde, Comoros, Guinea-Bissau, Mauritius, Sao Tome, Principe, and Seychelles, and 16 Caribbean SIDS: Antigua and Barbuda, the Bahamas, Barbados, Belize, Cuba, Dominica, the Dominican Republic, Grenada, Guyana, Haiti, Jamaica, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Suriname, and Trinidad and Tobago. And I chose those based on those which were classified as SIDS according to the UN. And I limited my analysis to SIDS because of 2 main reasons. One, these are countries that are recognized as being on the front lines of climate change. Obviously, they are among the most forceful actors on the international space with regard to advocating for enhanced climate action. They're also FDI dependent countries. Now, not all of them have bits which are enforced, and the level of bit activity or IIA activity by these countries really varies. And really what I wanted was a comparative study to see to what extent were Caribbean and African SIDS facing some of the same issues with regard to the compatibility of their existing IIA frameworks with their climate, their ability to pursue greater climate action. And the scope of the analysis was limited to those which were enforced, those agreements which were enforced and which were publicly available in English, French, Portuguese, or Spanish, because those are the languages that I speak. And then an exception was made in the case of BITS with Brazil, because those are not enforced, but they're among the best example of newer IIA practice among the countries studied. And the source of my information, the BITS and the IIAs in general, would have been the UNCTAD IIA Navigator. And I reviewed the preambular and substantive provisions of these texts, including provisions on investment liberalization, protection, promotion, facilitation, and the dispute settlement provisions as, according to whether they were included in those bits. This brief was policy focused, so it does not focus on an in-depth legal analysis or in-depth review of case law. It's more concerned with the policy. And in total, I reviewed 138 bits and 35 treaties with investment provisions. And then I had also wanted to see what were the movements in terms of the improvements in treaty practice that we've had, the progress on treaty practice. And the model bit, I was only able to find the model bit of Mauritius. I know that some countries, Barbados, for instance, have revised their model bits, but that model bit is not publicly available. So in terms of my findings, I concluded that Caribbean and African SIDS current IIAs are not fit for purpose for the purpose of promoting investment that serves their climate action goals. And this pretty much is the consensus in the literature. And current investor protections in these agreements open up these countries' climate adaptation and mitigation measures to legal exposure to investor claims. I found that Caribbean and African SIDS have not adopted a consistent approach to their IIAs. So there's a significant amount of variance among these IIAs in terms of their scope and ambition, as well as the content and wording of their substantive provisions. And so in many cases, what I found was that Caribbean and African SIDS IIAs with the same country partner tend to be highly similar or almost identical. And that, in a way, to move it to a more political economy analysis, it reflects the negotiating power, the asymmetric negotiating power that exists between our states and our treaty partners, that most of the time our bits more so reflect the treaty practice of the partner with which we have negotiated. And bearing in mind that the majority of these are what are called older generation bits, so they would have been signed in the 1980s, 1990s. The exception is the newer IIAs. So those IIAs which are treaties with investment provisions. There's a lot more development friendly language in there, but I'm getting a little ahead of myself. Okay, so another thing is that the vast majority of these IIAs that were reviewed really focus on investment protection. And this is not unique because at the time in the early 80s, 90s, etc., there was not as much of a heavy focus on sustainability and sustainable development. Yes, there were discussions about it, and there was work done. You had the Brundtland Commission, etc., but it was not as front of mind as it would be today. So what you find is that very few of these older generation treaties contain a development dimension or express language on sustainable development or any explicit reference to climate change or climate action. And therefore, these agreements, in many cases, are unaligned with these countries' climate and wider sustainable development goals. And so for instance, the preambles typically, don't mention environmental protection or commitment to climate action. They have very few carve-outs for state regulation for environmental or climate purposes, and they generally lack obligations on investor behavior, encouraging environmentally responsible behavior, that sort of thing. They tend to lack those. A difference, as I said, is that with regard to the more recent investment chapters, you're seeing a lot more incorporation of explicit development-oriented provisions, but the older generations bits do not include these. And then thirdly, although most Caribbean and African countries' experience thus far with investor claims have been limited, the threat of treaty-based claims is more acute because more SIDS are turning to oil exploration, which in a way seems a bit incongruous because on the one hand, you're promoting clean energy transition, etc. But then on the other hand, you are looking to, because of development imperatives, or rather growth imperatives, you are looking to increase oil exploration, etc. And that in a way could make you more susceptible to investor claims. And countries worldwide have begun amending and renegotiating their existing IAAs to include more express environmental protections. But with regard, and usually because of bad experiences that they would have had coming out of ISDS disputes, investor state disputes. But because we have not had as many disputes. We have had disputes, but not as many disputes as some other countries. My argument is that there does not appear to be the same level of urgency to reform our existing treaty stock as seen in some countries. And on another note as well, as I have mentioned earlier, the reliance of our countries on negotiating these treaties has differed. So as I said, there are some countries like Barbados and Mauritius which have a lot more investment treaties than say other countries where they might have signed but they haven't come into force. And in addition to that, similar to the international trend where there's been a fall off in the proliferation of new bits being signed, you're seeing that in the Caribbean as well, and in some African SIDS as well. And then the reform efforts, so they have been, so I'm not suggesting that there are not reform efforts going on. There are. I know there are reform efforts going on in both Africa and the Caribbean, but a lot of them seem to be more so focused on the agreements going forward, such as revision of their model bits, but not so much in terms of what to do with the existing agreements. A lot of these reform efforts have benefited from technical assistance provided by UNCTAD, for example. They have great tools such as their reform accelerator, their policy framework for sustainable development and whatnot, which is commendable and important. And they do have tools with regard to reforming existing bits. But I think in both the regions, a lot of the focus has been more so on prospective reform and not so much in terms of revising the existing bits, right? In terms of the SIDS. So Caribbean and African states, in terms of recommendations based on this, must conduct a systematic review of their existing IAAs to determine whether they're supportive or inimical to the goal of promoting and facilitating investment for sustainable development. As I mentioned, this process has already begun. And they must weigh the pros and cons of some of the available options. So, should you terminate, as some of our partners have done? So, like India, for example, um, or should we renegotiate? What would be the cost of this? Or should we include joint interpretive notes? In many cases, our treaty partners' IIA practice has since evolved, and there might be a lot more willingness than we know by the treaty partner to renegotiate the agreement to include more development friendly provisions. That is, of course, if we do decide to go that route. And then, as previous authors have warned, like Bernasconi, Osterwalder in 2020, in weighing the option of termination, states must give consideration to sunset clauses, which are contained in many of these treaties, which could mutually and whether they can mutually agree with their treaty partners to terminate these clauses. And then my second recommendation was that Caribbean and African SIDS, which make IIAs a key part of their investment attraction strategy, should reform their model bits, taking into account growing international best practices and other policy tools. As I said, I know Barbados, for example, has revised its model bit, but because this is not publicly available, I cannot say to what extent there has been meaningful reform in terms of ensuring that development interests are more taken into account. And as I said, UNCTAD has provided a lot of policy recommendations on this, and other scholars have provided recommendations in terms of referencing climate commitment in the preambles. There's been some discussion, like in terms of distinguishing between climate friendly and climate harmful investments, to the extent that you could come up with a formulation of how you want to define these, carving out climate actions from investment standards, obliging investors to comply with domestic and international law, committing to cooperation or action through institutional mechanisms, facilitation. One of the things that I found with a lot of our agreements is that, as I said, there was a lot of emphasis on investment protection in many of them, those which had investment protection provisions, but not as much focus on investment promotion. So if it is that we want to use our IIAs as a tool by which we help to encourage sustainable investment, then there needs to be a lot more proactive investment promotion within these IIAs. So maybe looking at some of the reforms, there've been lots of reform texts out there with suggested language that we could look at to decide ways in which we could be more proactive in terms of investment promotion within our text. And then another thing is with regard to including prioritizing financing for climate action as an objective or as an area for cooperation, as well as direct reference to climate action in the preamble and objectives. As we know, the preamble is a important part in terms of interpretation. Even though it's not a substantive provision, it helps in terms of the interpretation of the treaty. And additionally, Caribbean and African SIDS must consider whether IIAs are actually attracting investment and whether other instruments might not be useful. And there's a lot of debate in the literature as in to what extent do IIAs actually attract FDI. And I don't think that we have enough data, at least not publicly available, to lean towards the assumption that our IIAs actually attract FDI. I mean, there is anecdotal data that there are some investors that it might be comfort to them if they know that there's an FDI between their home state and the host state in which they're looking to invest. But in many cases, a lot of investors don't always consider these things until they find themselves in a difficulty, right? So that's something that should be taken into account. Another thing is that reforming IIAs should be part of a wider national investment for sustainable development strategy, and it's incumbent on Caribbean and African SIDS to align their investment policies and strategies with their development goals. So, and moreover, to ensure that they minimize challenges, they should be transparent in their environmental regulation and policy making, and applying changes or incentives in a non-discriminatory manner. And lastly, and this touches on one of the points I mentioned earlier, but I always have to put this as a discrete point, is that in terms of data collection, is you can find data with regard to FDI flows, but it's difficult in aggregate. But finding data on FDI flows by sector is difficult. And if we want to monitor to what extent we are attracting sustainable FDI, one of the things we have to do is to ensure that we have the data to show where is the FDI going, because how can we monitor to what extent FDI is going into sustainable sectors if we do not measure how much FDI goes to what sector. So I think that there's a lot that we have to do in the region there, in both regions rather. I think that one of the things that needs to be taken into account is that we have to see this reform as part of a whole development ethos, and we have to ensure that we have the data available in order to measure, so that we could say, okay, these are the measures that are working, these are not working, etc. So I thank you so much for your kind attention. I do look forward to any questions or any comments you will have, and I will hand over now to my moderator who would introduce the discussant. Thank you.
Thank you so much for that, Alicia, for providing such a comprehensive summary of the policy brief. I think it's evident that the work you've done is important for so many reasons, not only because of how pertinent addressing climate change is for small and developing states such as those within the Caribbean and Africa, but also because it highlights the need for a comprehensive sustainable development strategy within our countries, and also highlights a problem that I know we as researchers have often, which is the lack of data availability, because it would have, as you would have said, a lot of the information you would have needed to continue your work wasn't publicly available. And that's something that if we expect to make strides and advancements in these areas, we need to make it more accessible so persons doing work like you have the resources they need to go even further and to give. I think you've already given great suggestions and policy recommendations, but to be able to go even further. So I'm very excited to ask our expert discussant, Dr. Haynes, to give his reactions to what Alicia would have said and to give any feedback. And I look forward after he's finished for any questions from our audience joining us today. Thank you.
Thank you very much, Madam Moderator. Thank you, Alicia, for your excellent paper and the presentation that attended it. Thanks also to the SRC for doing these wonderful initiatives, which engages Caribbean citizens and researchers on very important topics like this. And so I'm delighted to be here, and I'm going to offer some very brief reflections on your paper as well as your presentation this morning. First of all, just to say that your paper was very well researched, and the fact that you, of course, engaged with the literature from both the Caribbean and Africa is something which we don't see quite often in the existing literature. And so that is quite commendable, that the depth and breadth of your research really reflected what you indicated at the very outset, which is your long-term interest in this particular discipline. So in that respect, I found the discussion to be a really interesting one, and one I think which reflects concerns across the Global South, concerns which I myself have expressed in many of my writings. I think for me, some of the key takeaways from what you've indicated, both in your paper but also in your presentation, are one, that there is indeed a dilemma that is facing countries in the Global South, but in particular countries in the Latin American, Caribbean region and the African region, with respect to how to balance that very uneasy relationship between wanting to attract foreign direct investment, and of course, protecting foreign direct investment once they're in your territory, and ensuring also that the commitments related to mitigation and adaptation in the context of the Paris Agreement are fully complied with. I think there is no easy answer to how this is to be resolved, this challenge, this dilemma. I think many of the recommendations which you have provided are really useful ones, and ones which I think, if implemented, would go a long way to assist in what many have argued we need, which is regulatory rebalancing. Now, the second takeaway is that indeed the Caribbean as well as African countries are confronted with what are inherently asymmetrical arrangements, including, of course, bilateral investment treaties, which many of them entered into in the 70s and 80s, but also in the 90s. Many of these arrangements were asymmetrical from the very outset in the context of the way in which they were negotiated. Oftentimes, there was a striking imbalance of power. And in fact, there is a literature that seemed to suggest that in the 90s, in particular, when many of these capital exporting countries were particularly inclined to sign these agreements with more developing countries, that action short or just short of duress was actually used to get our countries to sign on to these agreements. For example, in one instance, Grenada's representative, who had been negotiating at the time in the 1990s with the US, had fallen ill, and at that time wasn't clearly in a position to be able to fully articulate his concerns with respect to the draft agreement. But the representatives from the United States actually went to the hospital and got the signature for the particular agreement in question, which we now know as the Grenada United States Bilateral Investment Treaty. So if you do indeed do some digging, as you've done, Alicia, it becomes patently clear that many of these agreements from the very outset, insofar as the negotiations were concerned, were not concluded with our best interests at heart. And that's reflected in the range of provisions that are contained in these agreements, many of which you've referred to, would suggest that they are heavily asymmetrical in their approach. I can think, for example, of the fact, as you've mentioned, that in many of these agreements, there's very little by way of carve-out for climate-related action. And that's in large measure due to the fact that many of these agreements were concluded in the 90s and early 2000s, and even before then, the older generation bits as such. There is also another important takeaway, which I think needs emphasizing, because it's a concern which countries in the global south are increasingly becoming cognizant of, and that is the issue of regulatory chill. The idea that the very threat of investment arbitration before ICSID or other related bodies can have significant negative externalities for Caribbean and African countries in terms of their willingness to take climate-related action, which could ultimately result in not only a finding of liability on their part, but also significant damages. In fact, the existing scholarship does in fact seem to suggest that the idea of regulatory chill is a real one, particularly because more and more countries are becoming aware that investment tribunals are prepared to take very liberal interpretations of investor protection standards like legitimate expectations, which forms part of the fair and equitable treatment standard. And that is problematic because when one looks at some of the awards and damages that have been awarded in the context of, for example, litigation or arbitrations out of Latin America, it becomes very clear that these countries in the region can experience sovereign indebtedness as a result of one or two cases that are brought against them. And if you think of Argentina and the Argentine experience following the financial crisis there, that really suggests in very strong terms that the reality can in fact be meted out to our countries in Latin America and the Caribbean and indeed in Africa. And so indeed, regulatory chill is something that we are to guard against. It's a difficult proposition for many of our islands, and I'm very much hoping that litigators in the region who may be called upon in future to advise governments of the region may very well be aware that in as much as regulatory chill is a possibility. There are appropriate ways in which one can address those challenges, including in terms of the manner in which you interpret certain provisions of BITS. And of course, you mentioned the preamble as one of those sort of mechanisms which tribunals should incorporate in terms of the analysis, and which is woefully lacking in the existing arbitrations and the arbitral awards that have come out of ICSID in particular. We know from the Vienna Convention on the Law of Treaties, in particular Article 31, that once one has exhausted the ordinary method of interpretation, looking at the natural and ordinary meaning and supplementary methods, one can indeed refer to the preamble as part of one's analysis. And so in that context, to the extent that there are a couple of treaties in the region, particularly more recent ones involving Brazil and Guyana, which speak specifically to climate-related measures, or rather, more generally speaking, environmental-related measures, I think an argument can be made that reference to the preamble is a useful approach going forward. One of the other things that I found to be compelling in your argumentation, Alicia, is the fact that you made very clear the various ways in which the substantive provisions, often referred to as investor protection standards, are not only interpreted, but how they're actually worded in our various treaties can have seriously negative impacts on climate-related action, involving, of course, the possibility of regulatory chill, but also serious amounts in damages being awarded where a breach is found to exist. And you mentioned how the provision on expropriation is constructed in many jurisdictions without recognizing, for example, the police powers doctrine. I think you also mentioned the most favored nation treatment clause, the national treatment clause, and the fact that most of our BITs don't contain exceptions for climate-related action or environmental-related action, more generally speaking. And how dispute settlement mechanisms simply allow, in many instances, a free ride approach for many investors to be able to, even without exhausting local remedies as required by the Calvert Doctrine, to simply go to international arbitration. So those challenges are real, but I just kind of want to add some additional substantive challenges related to investor protection standards, one of which is performance requirements as a standard in international investment agreements. Now, there's a general prohibition on the imposition of performance requirements. Some bilateral investment treaties in the region, in fact, contain such provisions, such as the Grenada-US Bilateral Investment Treaty, whereby if you take certain measures that restrict the content of an investor's investment, or that impose certain restrictions, such as quantitatively or even qualitatively, then that can in fact give rise to a breach of the performance requirement. And the challenge with that, of course, is that it means that a state can take climate-related actions to the extent that that clause is included in the particular bilateral investment treaty, because the clause applies after the investment has come into the jurisdiction. And so in that context, and having regard to how tribunals have interpreted that particular provision, it makes it very difficult then to adopt climate action, whether mitigation or adaptation measures, to be consistent with your commitments under the Paris Agreement. There's another sort of clause as well that is of concern, and that is the umbrella clause, which converts ordinary breaches of investor concessions. For example, if a concession agreement is concluded between a state and an investor, which in principle has nothing to do with international law, but if there's an umbrella clause, as it is the case in many of our bilateral investment treaties, a breach of that agreement can give rise also to a breach of the investment agreement, i.e. the bilateral investment treaty, thereby giving rise to damages. And so that's another area of concern. And going forward, I think countries really need to pay attention to the existence of these clauses and how broadly they are drafted, and try to adopt various methods, including, of course, interpretive guides to guide themselves in terms of how, and tribunals most certainly, in terms of how these clauses ought to be interpreted. And on the point of interpretation, I think it's also important to note, and I think you mentioned it in passing, that there has been some movement in recent years to adopt newer generation bilateral investment treaties. And of course, that is commendable because many of these new bits include provisions or carve-outs as exceptions in circumstances where states have taken measures pursuant to environmental protection, including, of course, climate-related action. The challenge, however, is that because of the absence of the principle of stare decisis in international investment law, as well as the traditional broad interpretations which arbitrators have given to investor protection standards, it has meant that even where states have endeavored to include in these new generation international investment agreements carve-outs or exceptions, they've not always been interpreted consistently with what the states intend. Take, for instance, there's a recent case out of Colombia that was decided upon either a year or two ago, Eco Oro and Colombia, in which an environmental carve-out was included in the relevant free trade agreement between Canada and indeed Colombia for environmental protection. But in circumstances where Colombia had delimited the relevant area in the Amazon region such that the investor lost a significant portion of the lands that it initially needed to have used for mining purposes, the tribunal suggested that in that particular instance, that there had been a breach of the fair and equitable treatment standard, though it hadn't found that there had been an unlawful expropriation. And when the tribunal turned in respect of expropriation to the environmental carve-out, the tribunal essentially said that the state was able to prove that the police powers doctrine was applicable, i.e. that it could take appropriate measures for the protection of its environment. And, delimiting the particular area in the Amazon was one of those measures that fell within the police powers doctrine. However, even in as much as the court, or rather the tribunal did find as it did, the tribunal then went on to say that that doesn't absolve the state of its obligation to pay compensation in those circumstances, which from a logical perspective even, doesn't make any sense. Because if it is that a state is not liable on condition that it's able to invoke a carve-out, an exception, as it were, in international law, how then could the state be obliged to pay compensation resulting from the harm caused to the investor? And so these interpretive difficulties, which seem to pervade a lot of jurisprudence on investor-state dispute settlement, they're problematic for various reasons, including in as much as states are making efforts to reform their bilateral investment treaty landscape, really and truly, the arbitrators themselves are not acting consistently with their with concerns, I should say, for environmental protection and in particular climate action. And of course, as you might imagine, that is of a profound concern. One of the things that you mentioned also, which I found to be really interesting, is the assistance that is often provided to regional governments to enable them to conclude bilateral investment treaties and in many ways negotiate with key partners with respect to the conclusion of these treaties. And one of the things that is particularly concerning is that oftentimes regional scholars or stakeholders or practitioners who have knowledge and expertise in the areas with which the agreement or agreements are concerned with, they're not adequately consulted, they're not adequately engaged. Oftentimes, these international organizations, including UNTAD itself, would hire foreign consultants. And very recently, in respect of St. Vincent and the Grenadines, the World Bank that was funding the conclusion of a model BIT and bilateral investment treaties for St. Vincent and the Grenadines, and the national investment law also hired a foreign consultant. Now, the interesting thing, having seen in part because of my good friendship with a colleague who was working in one of the government departments, who then sent me a copy of the document, was that at no point was climate-related action environmental carve-outs considered in the contemplation of the foreign consultants who were drafting the relevant instruments. And it occurred to me that this perhaps is not unsurprising, in the sense that if it is that these consultants are being hired from particularly capital exporting countries, their interest, their expertise usually lies in the protection of foreign investors, and they're less concerned with the cultural and economic implications of investment agreements for the global south. So in that context, it occurred to me at that point that serious action is needed, particularly when our governments are concluding these agreements for full engagement with all key stakeholders, including local practitioners, local scholars who have expertise in the area, who are able to then to share their concerns, including concerns related to climate action. And so when you mentioned that, for example, when you had inquired about Barbados's model investment law, that you actually didn't get a copy because of confidentiality restrictions, etc. It then occurred to me again that if we're serious about climate-related action, we have to also engage with our local communities. And part of that engagement may very well mean breaking down some of those confidentiality barriers to agreements and instruments, more generally speaking, which our governments are concluding, so as to enable a fair and a transparent discussion around climate-related action and how it fits into these instruments. Now, one of the positive things, however, that I think one should bear in mind is that there is increasing emphasis among South partners like Brazil and Guyana, Brazil and Suriname, to include within the context of their bilateral investment agreements or even international agreements, more generally speaking, action related to climate change and, more generally speaking, environmental related action. That is, of course, a positive development, but of course, it doesn't quite get involved the key partners, the United States, that has the largest of the greenhouse emissions, followed by China, among others. And that, for me, is problematic in many ways, because if the key players that are involved in terms of greenhouse gas emissions are not actively concluding investment agreements that have and do in fact make reference to climate-related action, it means that we're not making as much progress that we think that we are otherwise making. Because oftentimes, as I've come to see, most of these agreements are concluded between countries in the global south, which of course is commendable, but it doesn't quite go as far as what we need to make meaningful action or progress insofar as climate-related matters are concerned. And oftentimes, even within the context of these agreements, they lack binding enforcement of environmental-related concerns. And so even, for example, in the Brazil-Guyana bilateral investment treaty that was concluded in 2018, in as much as it makes reference to environmental protection in one of the substantive provisions, it then goes on in the dispute settlement provision to say, this is not subject to binding enforcement. And so it does seem to suggest that countries have less appetite than one might imagine to deal with climate-related action in a way that is binding and imposes serious obligations on the parties in question. And then the final thing I would want to say is in relation to being cognizant of the negative externalities, more generally speaking, associated with climate action on vulnerable communities, in particular indigenous communities. And indeed, there are indigenous communities throughout the Caribbean. I think, for example, of Guyana, Belize, St. Vincent, Dominica, certainly in the English-speaking Caribbean. In Africa, you have the Endora in Kenya. You have the Ogoni people in Nigeria. And of course, in Latin America, there are several indigenous communities. The challenge is that in this movement toward green transition, governments have oftentimes ignored indigenous people's right to free, prior, and informed consent, and several other related communal rights related to land, related to culture, in establishing, for example, wind farms and other facilities, which in principle are good initiatives. But if it is that the negative impacts on the indigenous communities outweigh the measures that are actually being taken and their effectiveness, I suppose, in that context, then that is problematic. And I think that's something that is not sort of given serious contemplation when countries are thinking about climate action, but something that really needs to come to the forefront in the discussions that we're having about climate action today. So I think I've said enough, and I welcome questions and comments from our colleagues in due course.
Thank you so much, Dr. Haynes. I want to give Alicia a chance to respond to everything you would have said so far. I saw her taking notes, and I know she has a couple points that she would want to express first, and then I'll turn to the audience, see if we've had any questions submitted in our Q&A. I would encourage you to submit those now, either through chat or through the Q&A option. Thank you.
Thank you so much, Madam Moderator, and I'll be brief, but it would be remiss of me if I didn't say thank you so much to Dr. Haynes for his very considered comments and feedback, especially raising some issues that I myself had not considered in terms of the indigenous, the impact with regard to indigenous persons, and maybe the interaction among those three things, investment law, indigenous rights, and climate actions. I mean, that's a very interesting area for study. And then with regard to the very salient point about it's important to, yes, reform IIAs. And, you know, there is some debate in the literature with regard to should it be reformed or should we just do away with it? You know, so that's something to think about. But with regard to the whole fact that it might not be enough to just reform the IIAs, I completely agree with that point. And reform of IIAs is not a panacea. It's important, it's needed, but as you rightly said, Dr. Haynes, it's not something that is overnight going to solve the issues and the exposure that we face, especially when you have tribunals that are not as inclined to take a more favorable look on the environment when considering vis-a-vis commercial interests. And I take the point about the performance requirements, the umbrella clauses, etc., and the lack, of course, of engagement of local scholars. That is a very frustrating reality because, and I mean, it's not just in terms of investment law and policy issues, is in so many different things. We often value foreign over local, extra regional, in many cases over regional. So I thank you very much, Dr. Haynes, for your very considered feedback. And I do look forward to, you know, as always, continuing to follow your work. And I see Mrs. Nicole Foster, hi. So glad that you were able to join us. I'll hand back over to you, Adila.
Thank you so much, Alicia. I would just like to ask the audience if they have any questions. I don't see any in chat as yet, but I wanted to give everyone the opportunity to ask a question either to Alicia or to Dr. Haynes. Yes,
Adila, Nicole has a question. She has her hand up. Sam, is it possible we could unmute so that she could speak? Thanks, Sam.
Okay, thanks very much. So it is always a pleasure to see two of my favorite people. So my good friend and former colleague who is still well missed here in the law faculty, Dr. Jason Haynes, and my former student, protege, inspiration, all these things, Alicia Nichols. So really an excellent session. And investment law isn't even my area, but right, really very interesting. And I wanted to make a quick comment. And my comment relates to the point, Alicia, really Jason's point, which was one relating to the asymmetrical relationship and how that might manifest in terms of, not the best quality provisions as it relates to our interests as developing countries. And in fact, it's so funny because it then links to another point that Jason made and Alicia about local expertise. And so when my comment, the initial comment that I wanted to make was, I completely endorse and agree with the problems of asymmetrical negotiations. But my question is, the suggestion seems to be that the solution is one for, the world, for external to us. And I wonder if we don't want, so I am one that always maintains that we can do so much better than we currently do in the context of the negotiation of these things. And this is with all the limitations that we have of money, people, all those things. Because we have a University of the West Indies. We have, we have all of these resources. But in addition, outside of the university, we have bright young professionals who are able to make contributions in this space. And we also have to reflect on the fact that it's not Barbados alone. We are all in this boat together, right? We're all seeking, we're competing with each other for the same investors maybe, but in a sense, we're all interested in attracting investment. And so there's certainly, to my mind, a role for us to pool resources at the level of CARICOM. So for us to get, and I know, as I said, investment isn't really my area. I know many, many moons ago, there was a talk of a model CARICOM investment agreement. And I know that was taking forever to happen. And it was like painful, right? And so it may be that, that process is now dead, etc. But my main point is this, that I think we have to stop expecting persons to take care of our interests for us. We have to take care of our interests for ourselves. And in that context, we have capacity within this region to do better already, now, with no extra resources, right? Imagine how much more we could do if we really put a focused attention in terms of, really leveraging what we have and investing in more and better. And then also too, even if we're looking outside, there's a role, as Alicia said, we have to take responsibility as governments for the decisions that our government, as states for the decisions our governments make. I mean, I'm in a process right now where we're doing electronic single window for the purposes of, upgrading our system, etc. That is a process being managed through with the assistance of UNCTAD. But I assure you, there are local experts on it. That process is being, not from Barbados, but from CARICOM, if you get what I mean. So there's at least one person, I think their background, they're originally from Jamaica, and the other person who's leading it is from St. Lucia, right? And so, no, I don't know how they ended up in charge of the project, if you get what I mean. But what I'm saying is there clearly must be a role for our governments when we are negotiating with our partners, because the World Bank, etc. Yes, we're getting money from them, but they're our partners. We put money into the World Bank too, right? And so there clearly must be a role and a responsibility on our part to say to the World Bank, when you put together this team, I need to see that this team, even if it's not led by somebody from a region, that it has a player or two who don't have, not just there for name, to have credibility, but have a substantive role to play in this team. All roads lead to us at the end of the day. And I think it is a dereliction of our duties that our governments have to ourselves, that we continue to let ourselves be played in this way. We can do better. We should do better, and we must do better. And that is at all levels that I've talked about. I mean, my particular bugbear is the lack of use and leveraging of the UE for obvious reasons, because I'm at the UE. But it doesn't stop at UE, as I said. And UE is an institution, a CARICOM. We're a CARICOM institution. And you would figure that in the scheme of things, therefore, we are the first call, not the last or the never call, right? And so, and I also wanted to endorse 100% the need for us to create greater access to information for those who are in the academic space, to allow our students to be able to benefit from what is happening in those processes, but also to give those who work in the space within the university environment and more broadly to have an opportunity to contribute, but also to build their knowledge base, etc., in terms of cutting edge teaching, etc. Over. I'm off my soapbox now, but I don't know if either Jason or Alicia have information about where we might be at a CARICOM level, if that's now a dead, that's now done and dusted. We're no longer bothering with that. But regardless, even if we're not able to move at a CARICOM level, and I appreciate that individual states may feel they have unique interests that need to be addressed at a national level, I still maintain that we can and must do better, and the buck stops with us, not with anybody else. Over.
Thank you so much, Nicole, for I completely endorse your comments. With regard to the CARICOM, the discussions on the CARICOM model agreement. Jason might have more information than I would, but I think that lends to one of the problems that we discuss here, the fact that there's very little public information about these things, right? And in addition to that, a lot of the interests that we have, I do know a couple of years ago, one of these sticking points is that we have different interests within the region with regard to certain things. So some states wanted a broader definition of investment. Some states wanted a more narrow definition of investment. There was, there was some, there was not cohesion in terms of should there be creation of a special regime for just CARICOM investors, or should it deal with all investment regardless? There were lots of sticking points and discussions, and to be honest, I really don't know what stage it's at right now. That is one of the biggest problems, the lack of information. I mean, I always find it particularly frustrating that I can go on the EU's website and find out everything that the EU is doing, whether they're negotiating. I mean, you could see all sorts of things with regard to the countries that the EU is negotiating with. And then with the US as well, you could find a lot of things on the US website. And one could probably argue that that's probably a function of their capacity. They're able to put out a lot more information and process a lot more information in a timely manner. But it is particularly frustrating for us as researchers that you cannot get the level of information on your own region that you could get elsewhere. And then when you do get the information, you have to use backdoor means, so to speak. You have to speak to somebody who is working in the area. And obviously you don't want to breach confidentiality because in many cases, they're telling you things off the record. So I'm sorry, I don't have, maybe Jason might be more appraised than I am, but I am sorry, I really don't know what's the status at this point in time.
Yeah, I mean, just to reiterate everything that has been said, and I think, it just kind of reaffirms the point that we've been making, that in as much as we understand that there's a need for confidentiality among colleagues and stakeholders in respect of these decisions that you're taking, when the decisions concern the public, or at least have public implications, we, the people, ought to have sight or at least participate in that decision-making process. And I don't think there's anything more in a legal context that could have more implications for the members of the public than international investment agreements. The awards of damages, they're so significant in many cases that invariably it's going to have an impact on public policies in many jurisdictions, including social. And so in that context, I think we, I suppose, have the obligation to demand more of these government stakeholders. But at the same time, I think there is indeed a sense I've gotten from colleagues, particularly working in the big institutions, the World Bank and so forth, that to the extent that they're providing the finances, they control the narrative. And I do appreciate Nicole's point, which I think is well made, and particularly because, of course, she herself served as a negotiator several years ago in Geneva. So there are practicalities on the ground, and I certainly agree with you that perhaps the excuse that we don't have expertise and we don't have influence might have stood in the 70s and 80s. But with all that has happened since then, including, of course, University of the West Indies, we do have the capacity, I think, to make an effective contribution. But I can't help but think, nonetheless, that the powers that be, particularly those that control the narrative, really impact in a very negative way, I imagine, not only access to information, but also what goes into provisions. And in that context, I think your argument, Nicole, that perhaps then there's a greater role for a collective initiative as opposed to an individual island initiative makes really good sense. Because again, and it's relevant equally in the trade law context, if you're bargaining as a collective, you have more power as such to be able to have things included that you otherwise would not have had included if it were just you negotiating. So I think, a lot of what we're seeing here has actually been repeatedly said over many and many years. It's just that the people who are in power and who have the authority to make these types of decisions are not listening, or don't seriously take the views of people like ourselves. And this conversation, I'm sure, will be had over and over again for the next several years. And it's really unfortunate that as a region, we have not learned. And it probably is going to take a really bad disaster, whether or not a natural disaster or an arbitral award that is staggering, for us to get to the point where we recognize that action is actually needed.
I completely endorse that. Sorry, Madam Moderator. There's some questions in the chat, so I'll hand over to you.
Thank you, Nicole, and thank you to Alicia and Brian. Sorry, Dr. Haynes, for your response. Yes, I said Brian because the first question I'm going to read is from Brian Leacock, who asks, could it not be said that bilateral investment treaties are intended to be asymmetrical by their nature, as they are agreements that are intended to protect investors? Henceforth, should a host state wish protection against investors, they should utilize domestic law provisions and not BIT. That's the first question. And so either of you can take that.
Brian. So Brian is one of our young, bright ones who was at the faculty and since has qualified and is in London doing his thing. So I think, that goes back to the age-old sort of concern in terms of what exactly is the purpose of bilateral investment treaties. And I suppose if you take a conservative view, you might very well arrive at the conclusion that yes, it is to protect foreign investors. And by its very nature, therefore, it has to be asymmetrical. But I think when you look at not only the preambles of these bilateral investment treaties, but also many of the substantive provisions, it is clear that these treaties are actually meant to assist in economic development, but also they're supposed to be interpreted in a manner that is fair to both sides. So in fact, very recently, the majority of tribunals, or rather some tribunals, have been reiterating that, for example, the fair and equitable treatment standard has to be interpreted fairly and equitably, because that, by its very nature, equity means that both sides, their views and their concerns ought to be taken account of. So I do appreciate your concern, Brian, that we have too much of an expectation of an investment regime that is intended at the very outset to protect foreign investors. But I do think that countries, when negotiating, had in mind also their economic development and not simply just the protection of foreign investors.
And thank you so much. I'll just add to what Dr. Haynes said, if I may, that one of the issues as well is the fact that a lot of countries were decided to sign on to these agreements because there were concerns about investors, especially with regard to Latin America, about the fairness of the local tribunals, which obviously persons will argue some investors didn't have much faith in that they would get a fair outcome before local tribunals. So therefore, having this international investment regime where you could bypass the local tribunals and go directly to ad hoc international tribunal where the state has no influence over it, that was seen as being fairer to investors, right? As Dr. Haynes said with regard to, there was this whole thing about protecting investors. The thing is, though, is that especially with regard to small states, given the asymmetries of power and the fact that in many cases, there is, there are investors whose revenues are far exceed even the GDPs of some countries, that asymmetrical power shifted. So whereas a lot of the thinking behind the conclusion of these investment agreements was that the asymmetric power was the state being more powerful than the investor. When it comes to smaller states, it's the small state versus the investor. And a lot of the reform discussion has been around to what extent do we continue to allow investor-state dispute settlement as one of the recourses that an investor could take under an investment agreement? So, in some cases now there's only resort to state, or in some cases there are carve-outs with regard to what exactly which provisions would be subject to investor-state dispute settlement. So, really great question. There's a lot of discussion about this. And I think those are some of the things that we really need to consider as we reform. I see some other questions, but I just wanted to jump in here to note that I am not entirely convinced that investment agreements really benefit the region. I personally have not seen any empirical evidence to suggest that they do. And I think in many cases, the legal jeopardy that we are potentially placed in because of these very generous investor protections far outweigh any quote unquote signaling effect or investment attractiveness effect we get from BITs. And I still would like to, I still don't know if really and truly signing these BITs is really that beneficial for us. I see two other questions here, if I may, Madam Moderator. One of my former students, hi Caroline. I see some other former students here, hi. With regard to your question, Caroline, I do agree that there is a need for more South-South agreements. My only thing is that and there's been a lot of discussion recently about the utility of the term global south and whatnot, given the very heterogeneous very heterogeneous makeup of the global south. And really and truly, sometimes signing such an agreement with another global south country, you might not be in any better position than if you are signed with a developed country, right? So yes, I agree with more South-South development. I think that at the end of the day, we have to bear in mind that even if we do we do encourage more of these agreements with other South-South countries, and a lot of the BITs are actually between South-South countries, to what extent are they really development friendly? Just because they're with another country, the global south, might not necessarily mean that they are conducive to development. Madam Moderator, over to you.
Thank you so much, Alicia. I don't believe there are any more questions in the chat. I believe that is all. I just wanted to give our speakers one last opportunity if they wanted to make any final comments before we close. And so, Dr. Haynes, if you have any comments, if not, move forward.
Yeah, I mean, just to say that it's quite heartening that we're having these conversations, and kudos to Alicia, yourself, Adila, Janice, and just everyone who has been having these conversations, because I think the more we reiterate, probably it may very well be that the powers that be will hear what we are suggesting and then ultimately intervene. It's also quite heartening that the conversation also involves a lot of the younger folk who are now coming out of school. I can just look at the participants list, and I'm seeing at least 5 or 6 of my former students, many of whom have gone on to master's programs in this particular discipline. So we are building the capacity, and that's certainly a positive development. And I think that, in future, once we continue having these conversations, eventually we'll get through to the powers that be, and hopefully they'll listen to us.
Okay, thank you so much. And so before we close out, I would like to end the session by saying thank you. Firstly, thank you to both of our speakers, Alicia, for your work not only in writing the policy brief, but for coming here today and presenting so comprehensively everything to us. Thank you, Dr. Haynes, for your excellent work as our expert discussant. I want to thank everyone in the attendees list who either just watched or made a contribution. All of it led to a fruitful discussion. I would like to thank Samuel Eugene, Mr. Eugene, and his IT team for all of their work in making this possible. I would also like to thank the UE Marketing and Communications team and SRC Director, Dr. Janice Remy, and all of the SRC staff for their help in organizing and making this possible. This has been an incredibly fruitful conversation, and I look forward to all of the other outcomes that will come from this discussion going forward. Thank you.